I do not know how the Karen Read jury verdict can be explained, but let's look forward.
Yeah, I think they were overloaded with too much information by the prosecution.
Coming up, we have 10 cups of reasonable doubt. The reasonable doubt in the Karen Read case is pouring out of the red Solo cups. I'm Lainey Law.
And I'm attorney Andrew Myers.
And today we have the wonderful attorney Yoli Medina. Yoli, how are you doing today?
Fine, thanks. Thanks for having me.
So the Karen Read case has been an explosion. Very surprising. The jury was at a deadlock, could not come to a conclusion, could not make up their minds. Some people felt really strongly one way. Some people felt really strongly the other way. I'm a little surprised. From the beginning, I thought there was reasonable doubt. If we're trying to prove intent, what proved intent?
Well, it's tough. It's really tough to make sense of exactly what happened in the jury room. I mean, we don't really know exactly. We've heard rumors. Yeah, you can comment all you want down below, but don't say because at this point, as we record this, there really has not been a lot about exactly what happened in that jury room. But we're going to talk a little bit, but then we're going to consult on this episode with Susan Constantine, who is a very well-known jury consultant and human behavior expert. And I think she has a lot of good thoughts about this. But Yoli, what's your take on the jury and what happened?
Well, I just think that there was such a divide in general, like pre-trial. There were those who were rooting for Karen, and you had Turtle Boy, you had other people rooting for Karen, and then you had other people who were in law enforcement locally who were dead set that she was guilty. And then you have John O'Keefe's family who believes that, Karen Read was being prosecuted because she did it. And so, there's such a divide. It's like a political divide that that makes it hard to come to a consensus. And what concerns me more is a note that the jurors wrote, the last note about having strong convictions and, deeply held convictions. And I'm wondering, should the judge have issued some kind of a admonition that your convictions, your thoughts, how you feel, you need to set that aside and look at the evidence. And if you can't do that, you need to let me know now.
Yeah, I think that's a good point. Why don't we go right to Susan Constantine, and we'll start on that note, Yoli, about that jury note, which I think was quite troubling to everyone. We are now with Susan Constantine, who is a jury consultant and a human behavior expert. Susan, welcome.
Thank you. Thanks for inviting me.
And with us is Lainey Law, of course, Southern California attorney Yoli Medina, and I'm attorney Andrew Myers. I guess I'd like to just first ask you about this note that came from the jury to Judge Cannone, and I have it right up on the screen. Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet the standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. Susan Constantine, you're the expert, but I found this troubling, having tried a bunch of jury cases, that they were stuck on individual principles and moral convictions. What's your take on that?
Yeah, I mean, this was powerful. And I thought that the words that they used were very descriptive in the deep level of divide they had, but they never mentioned regarding the evidence that they heard. They didn't come back with any other questions regarding, the juror questionnaire, the verdict form. They came back with the fact that we have our own moral beliefs that are so deeply rooted, we can't move past it. So this is really riveting to me, because that's telling me they didn't answer those questions to those jurors to help them to move along past feeling guilt or shame by making the decisions they had to make. So this is why I think that trial consulting is so important, pre-trial intelligence, testing these arguments beforehand to seeing what types of jurors and the questions they have regarding their moral beliefs. But I think that this was a complete divide. It wasn't just one juror. It literally was like the, opening up the Red Sea and the split right down the middle. So I would love to be able to heal for some of those jurors, but I think this was really telling in this case.
Well, whose job would it have been to screen this out? My understanding, and tell me that I'm right or wrong, my understanding, and I always feel very uncomfortable impaneling a jury. Mm-hmm. My understanding is you're supposed to leave your individual principles and your moral convictions at the door and come into the trial with an open mind to all of the evidence, then go back and deliberate based only on that evidence. And moral convictions and individual principles, tell me I'm right or wrong, are supposed to be left outside when you go into that courthouse.
Yes, but the point is, Andrew, humans can't. I think that we need to get beyond the fact that, if you ask them a question, in fact, I've got the juror questionnaire right here. I went all the way through it. And the main thing was, do you have any religious or physiological beliefs that would make it difficult for you to follow the law and come to a verdict in this case? Those are yes or no questions. Why are we asking them just yes or no questions? We need to get deeper beyond the surface level because we're expected that they're going to say yes or no. So, they are supposed to set this aside. But what happens is some jurors don't even realize that the biases that they hold, that from their previous experiences and belief systems, are so deeply rooted, they don't even know until they're triggered. And when they're triggered, then all of a sudden it's like, oh, okay, I didn't even know that was there inside of me. So it probably could be innocent because they may not have known that they harbored biases. And the thing is, we all do. But to ask them that question, if they can, I always thought that was the stupidest question. But because
so there needs to be more on that. I'm going to ask you a hypothetical question, and the hypothetical question is that I'm hired to represent Karen Read going forward. Now that's not going to happen because she has a fantastic team, and I would never compare myself to them. But I come to you and hire you to help me select a jury. And it's something that I've always felt a little bit uncomfortable with, even though I've gone to seminar after seminar with some fantastic groups of top trial attorneys. So I come to you and I say, Susan, how do I try this case and defend Karen Read? What do you tell me in terms of selecting a jury? How do I do it?
Well, I come from a place of, I want to know before I know. So I want to know a lot of these different pieces and questions before I actually go into the courtroom. So I'm already doing some pretrial intelligence, which means I'm doing a mock or a focus group in using virtual jurors. Okay. And I'm now, then trying the case inside of a focus group with live participants. So I use a virtual and live panel. And then I'm having both the state and the defense, but from the defense side, they're playing both sides. And then we're asking these questions. We're opening up this dialogue and we're looking to see, are those virtual jurors responding the same as those live jurors? Or is there a disconnect? And then you start showing them different key points of evidence to seeing how they're going to respond. So before I even walk in that courtroom, I got a pretty darn good idea about what they like, what they don't like, what fell flat, what really worked. Was it what demographic liked this question better than that question? I'm already armed with a lot of information. Here's where I think, and forgive me, lawyers, I think you guys are missing the boat, is that you need to have someone that is specialist in behavioral analysis. So you guys are so busy doing what you need to do, what you do really well. That's try the case, right? You need a person like me that's watching all of the responses. You need someone like me that can read every little minute micro expression or movement or grimace or a contempt or a pressed lip of maybe disdain or confusion. That's what you're missing. So my biggest beef is you guys do what you do. You need to let me do what I do. And together we're a really great team together inside that courtroom when it comes to deselecting those jurors.
Yeah, because
So
it
I
is
guess
about
one of the questions that I have is because, as we see on the note, it says convictions, and you're talking about not asking close-ended questions. And it's funny that you even bring that up, because way back when, even when I used to work in retail, one of the things they say is make sure you're asking like open-ended questions, is just like try to get them to expand. So do you think that with the context that it was moral convictions and the context of the questions that they're asking, do you think that there was issues with the jury selection? Do you think that there was issues with making sure that people understood what they were supposed to be doing? Where do you think that this kind of fell apart?
Well, I don't really know at this point what the responses are from the jurors. Like, we haven't heard, but only from one of them. We just know that there was a divide. So then that takes me to, they said moral convictions, their own personal beliefs. So during jury selection, were they able to unravel that? Were they asking the inquisitive questions, the one that are going deeper? Were they limited? Were they limited to a few questions, 2 or 3 questions, be able to get through those many jurors? So with that being said, that really would have prohibited it. But keep in mind, the more people talk, the more they're going to reveal themselves. And what I do is I analyze every single word they're saying, because it has context, it has meaning, how it rolls off their lips, and in order, how does it roll off their lips? What specific word did they use, and what was the meaning to that? Are some of the other jurors also shaking their head, or they're shaking their head no, or are they disengaged? There is a wealth of information that we can learn from this. But I think it's not just one. I think it's a couple things. I think they over inundated those jurors with way too much information, overkill, and they can't really remember everything. 15 to 20% of what they hear, they're going to recall. So I'm going to give you guys a secret. I'm going to give you a secret. And I want you to pay attention. If you only do one thing that I'm telling you to do, this is going to help you. If you want to know what that juror is thinking, just watch every single time this pen goes to the paper. That simple. So when you do that.
Wait a minute. Whose pen? Their pen when they're taking notes, or your pen when you're taking notes? I don't get it.
During, now let's go past this. We've already picked a jury. Maybe I jumped ahead. Now, since the jury's already seated, if you want to know how your trial is going, just watch the jurors. Who's putting the pen to the paper at what time? You're going to be able to find a theme. Who they like, who they don't like, how long they're writing. And you want to see if you can see if there's a pattern with just one, or whether there's more than one. What's important to them? Because now, once you know what's important to them, then you can meet that need. So they give you all kinds of nonverbal information. You guys are just sometimes missing it. So, this is a multifaceted issue. So if I were there and I'm in the courtroom, I would say, you got to open up more of a dialogue with those jurors. Wasn't there, so I don't know. I would, if there was a question that somebody asked on the juror, can you be a fair and impartial juror? Can you set aside your own personal biases? And, regarding law enforcement, whatever it is. And if that person says yes, I want to see, does she say yes, or he say yes, or do they just say yes? Or do I see yes with a little shoulder shrug? Okay, I'm looking at those inconsistencies, and then I'm going to go right in. Well, tell me a little bit more of an example when you've used this, or has there ever been a time when? So you got to open up what they're thinking and feeling, because keep in mind, their entire life and history is all stored in files in their brain.
Okay, Yoli, I'm interested in your thoughts and questions, because Susan tells us we're not doing our jobs properly. What are your thoughts, Yoli?
Well, I tend to use my intuition a lot when I'm picking a jury, and it seems to work for me. And I kind of, I don't know how to explain it, but it's sort of, I mean, I can't explain it very well, but when I'm picking a jury and I'm asking questions, sometimes they may say yes, or they may say no. I've had somebody work in law enforcement, but I don't have any biases, things like that. And I kind of I can maybe believe, like I use my intuition to tell me whether they're telling me the truth or not. And I do look at micro expressions and things like that because I have a bachelor's degree in psychology, and I use that, and applied psychology, and just, with groups. But, it does help because you can't, having a jury consultant, because you can't be looking at the jurors all the time. I mean, you can't. And when you're cross-examining somebody, well, the way it works is when you're cross-examining somebody, the jurors should be looking at the attorney.
Mm-hmm.
And then when you're doing direct, the jurors should be looking at the person on the stand. And so that's easy to judge, but other things, when you're in the actively questioning people, it is very hard to see how the juries are to see the reactions. So sometimes I'll have a co-counsel, or I'm the co-counsel, where the co-counsel's job is to watch the jury. But that's not the same as a trial consultant.
Susan, I understand that you went to CrimeCon this year, and you did a poll. And A, tell us the results of that poll, and B, how do you overcome that kind of a divide?
Wow. It was really interesting because I had to think about what case I wanted to do at CrimeCon. So I wanted to do something very interactive involving the group. So I had close to 5,000 people that were in the room. So each one of them were given a little paddle, like for yes and for no. And then I would open up with kind of the overall, what do we do behind the scenes? Because that was what it was all about. So what do we actually do? Then what I did is I showed I've got my PowerPoint actually right in front of me. I showed the opening statements of both the state and the defense. And then I talked about some of the key points of evidence. What were the things that we're going to be looking at today? Which we had to do the tail light. Which ones were more credible? Where did you find the witnesses credible? And then I didn't persuade them in any way. I just wanted them to give me just a raw initial reaction, like Yoli was saying, they had that gut reaction, right? Mm-hmm. So after I opened up the opening statement, which one, I said, which one do you favor? Are you more pro defense, pro prosecution? And they would raise their hand. So what we found is that, and I think you guys will find this too, is that when you get that first vote, it generally doesn't change. That first impression a lot of times doesn't change until even at the end. So the majority, 3/4 entire group, all voted that they thought that Karen Read was innocent. And so another quarter of them thought that she was guilty. So keep in mind that now you're looking at who are the demographics in that audience, right? Same demographics that was in my audience were the ones that were outside that courtroom.
Yeah.
Women. Right in that middle-aged group, right? Those are true crimers. And so it kind of shows you what their feelings were. So then I would show them key points of evidence, show them video of the taillight. Do you think that Karen Read hit the car? Do you think that she hit O'Keefe? And most people said, the majority of them said that she hit the car, the other SUV. So that was really important because it kind of gives you insight. So why that's important, I want to kind of back up. I had already done before a session that I did, I already pulled over 100 virtual jurors on the same thing. So I already did that. I used Emotion Track. We worked together. I have a patent technology, by the way. It's called the Jury Lab. It analyzes human behavior, facial expressions, up to 12 people in a panel. So it was a combination of both. I did the Emotion Track for the virtual, and then the other one, which is my own training and my own patent on the technology. So bottom line is I had them cast their votes on yes or no. And I did that all the way throughout, peppering them with all kinds of different evidence and seeing what their responses were. So at the very end, it was very surprising, just to see the results. And the other thing, what we did was we analyzed the sentiment of different pieces. For example, there was one of the attorneys says, so who took the defense says, so who took the photo? Karen Read took the photo, right? So remember that part? So we looked to see who spiked. So in that one, it was primarily women, and it spiked at 100%. So that piqued their interest. So now I know what we're going to use, what we may not use, to seeing what the sentiment was based on certain questions. Another one was first responder Brian Allen never came out of his house. Remember this one? Spiked super high.
Do you mean Brian Albert, the owner of the house?
Yeah, Brian Albert never
came out of his house. Yeah.
Right. So that spiked. I was like, oh, wow. Okay. So now we know if you were to go into the retrial, you need to be hitting that one because that spiked interest. There were other parts of it just fell flat. No affect, no emotion, no nothing. So I think I got off track.
But I think what you're saying is on retrial of this case, which is going to happen. They've Michael Marcy, the DA in Norfolk County, said we're going to retry the case, and I don't see any other option. What you're saying is on retrial, the attorneys need to sit down and look very carefully at the evidence. And from what I'm hearing from you, there was too much evidence. There were 30 plus trial days. There were 74 witnesses, 600 plus pieces of evidence. So what you're saying is they need to kind of hone it down and narrow it down into what evidence is going to help them and maybe kind of leave some of the spurious stuff out.
Right. Do it in, little mini chunks. Do it in tiny little chunks. Can you remember I got to tell you, I'm 66 years old. Okay. I'm no offense, ladies and gentlemen. I can't remember what I did in the morning. So you're trying to telling someone that's pretty astute to remember and recall all this information unless they put it on a piece of paper. And then the other thing is, how do we know when they heard something, what did they write on the paper? How did they interpret it? Because if you asked 3 or 5 other people, did they interpret that same evidence the same way and write down the same thing? Right. Or, it's kind of like, you whisper in one ear and at the end of whispering in 3 or 4 years, you come up with different perspectives.
Right.
So, bite-sized pieces. I also think that any sort of strong visualization and then tugging at their heartstrings, those two, visual and then kinesthetic, are really powerful. The problem that we have is, especially with the state, that his tonal value was so monotone and flat. I'm like, I'm falling asleep.
Yeah.
And the bubbling around and
What, if anything, do you think he can do to change that other than have a new attorney try the case? What, if anything, could the Commonwealth do?
Well, that would be great if they could use more than one person. Shape it up, use a couple of attorneys kind of weaving back, tag teaming different pieces to create more interest and changing a state of mind. Oh, here's another different person. I need to be paying attention now. So, you got to keep changing these states of mind. As you guys know, when you even listen to a commercial, right? There's an attention span and then you kind of fall off. We have to keep that attention span all the time. And
let me ask you this. Let me sharpen this down. I know you're a very studied, researched person, and we could talk about this all day, but let me ask you a final question about the Read case. And that is, based on everything that you've said, everything that you've heard, and based on, your background in psychology and all of our knowledge about confirmation bias and the fact that 75% of the people thought she was not guilty and 25% of the people said she is guilty, and people have these moral certainties. When the case is retried, what chance do you really think there will be a different result? Didn't Albert Einstein say something to the effect of the definition of insanity is doing the same thing over and over again and expecting a different result? Do you really think there will be a different result in another trial?
They're going to have to change things up a little bit because of all the pretrial publicity and all of the people standing outside. They're seeing all of this. They've either got to change the venue, they've got to sequester those jurors. They need to do something different so they're not so inundated. So the answer is, I think it could change depending on, we don't know yet. So was it split 50-50? Was it split 10-2? What was it split? We don't know.
We don't know
If
yet.
there-
Yeah, we don't.
if there were only a couple people, then we would have a better chance of maybe we got a different jury and we retested all of these key points and then seeing where they lay, then we may have a chance. But I do think you have some very strong embedded belief systems, and I think it's beyond just their emotion. I think it could be political, and that may be a big part of it. So we need to make those jurors feel comfortable in making a hard decision and not feeling that they're going to live with guilt and shame leaving there from that point forward. So we have to empower them to be more objective rather than being super subjective and then going inward. They need to look at it outward. So that is it's a very fine line how you do that. I do think the defense is really good. I think those guys have really nailed it. So I wouldn't change anything they did, just kind of keep it more concise, more laser focused. And here's the other thing I would recommend. We got to work on the defendant, Karen Read. I think that there has to be a sense of empathy that she's not showing. And that I think is a big one, because they said the words feeling or beliefs, those are emotional things.
Yeah.
She was a snark. And I think that didn't always go over well with everybody. So I think that if you could create some vulnerability with her, you could create some softening with her, not to emote so much in the courtroom, I think that she would have a better chance of softening and people being more believable. And I think she needs to show more empathy towards the O'Keefe family, because I think the one juror said, I kept looking over at the O'Keefe family, and they had a hard time stepping over that dead body and finding her innocent.
Okay, well, thank you for that. Thank you very much for that.
Yeah, I believe Susan made a lot of interesting points. I think that, especially from a layman point of view, I don't really think about a lot of the stuff that goes into jury selection. I mean, we talk about a little bit that you got to find someone who's unbiased, but I think it goes to show, like, you can say yes, you can say no to questions, but she really pointed out, what kind of expressions are people making and all of the analyzing of their behavior, which you can't get from yes or no questions. You can't get from just filling out a questionnaire. This is one of the things, we live in a world now where we all do things online. We're all on Zoom, and it makes things a bit harder too. But it was interesting seeing her opinion on it.
Yeah, it was interesting. I mean, jury selection has come quite a ways in Massachusetts. When I first started practicing law many years ago, you just basically got a card and strike people. You could ask them a couple of questions, and juries were generally selected fairly quickly. Now that's come a long way. It's not done that way anymore. But I would think that you're right, Lainey. That was a good insight, that, more needs to be done to figure out how to have jurors be honest about any personal convictions they have or moral convictions they have. One of the things that I've heard, and that, it's just all speculation and discussion. One of the things that people have said in some of the comments of some of the other material that's out there is that someone on the jury had a moral conviction about sending anyone to jail. Now, if that's true, and we don't know if it's true, if that's true, that person shouldn't be on the jury, because that, and I know it's all de rigueur. We don't judge people. If you're in a jury, that is your job to judge people. And the jury, all the jury does is come back with a verdict, as you know, Yoli. It's up to the court to do the sentence. So it's not even the jury's job to say, at least at this phase of this trial, sure, there are cases that are bifurcated and then the jury decides. But in this case, in this trial, in this particular case, no, that's not their job. So if that's true, they
need to be weeded out. I mean, those are the things that's why when that note came in, that's why it seemed like they were not basing it on the evidence. They were having some kind of either personality clash or some moral. When you're in that jury room, I used to hear people like arguing, like you could hear voices,
Really?
Yeah, people would get very, especially in a case like this, where there's a divide, I mean, you have to weed them out. And I've always used my intuition, but it's good to have somebody like a jury consultant if you can afford it.
Yeah, I've actually Susan Constantine is very well known nationally, obviously, and we were lucky to get her to come talk to us. I actually knew a jury consultant in a previous life, and psychology is generally what they are experts in, and they pick up on little cues. Some of the cues she was talking about were too late because people were already, empaneled and sitting there and writing their notes. So those things would be good to pay attention to and focus on going forward for the next trial. But I don't know, other than asking a lot more questions. And she made a good point about yes, no. That's not really a good thing because anybody can be less than truthful and say yes or no. So to kind of penetrate into that a little bit more. And I've taken seminars on jury selection, and they go all day. And at the end of the day, they say, we haven't scratched the surface. So it's a tough job. It really is. The other thing that just really struck me here, Yoli, was that I started out, and people can yell at me all they want to put out on the down in the comment. I started out, thinking, this whole, Karen Read is innocent thing is crazy. That's how I thought. I thought that this whole, free Karen Read was just a bunch, not really based in anything. Then I went into the trial open-minded, and I watched it all. Some of it I couldn't watch live because I am still trying to practice law. So I'd go home at night and watch, on YouTube, you can watch it all. And so I would say 90%, to be honest. And the more I watched and the more evidence came in, I said, she didn't do it. There's way more than reasonable doubt. She didn't do it. And they didn't prove there was even a car accident that a car hit her. They didn't even prove that. So,
and so what's funny is I didn't know hardly anything at all about this case. I didn't follow it until I did that show with you where you told me about it and I asked you questions. And then, so I got up to speed, and I got up to speed on the parties, who's what, the Alberts, the McCunes, I got all up to speed. And then just a few, I couldn't watch all the trial, but just the inverted image of that, of the car, then the, throwing away the cell phone when you're told not to, and then, it's crazy.
Let's look at 10 reasons. I have 10 reasons that the Commonwealth did not prove its case, and we're going to call it 10 cups of reasonable doubt. And what you just said is number one, the inverted Lexus. Prosecution showed the jury Karen Read's Lexus SUV backwards for a whole day of testimony without disclosing the fact that the video was backwards. They said inverted. It was backwards.
It was backwards. Yeah.
And there was a mysterious figure lurking by what appeared to be the driver's side rear of the vehicle, but because the image was shown to the jury backwards, the lurker is at the rear passenger side where prosecutors claim the broken taillight was. So that's reason number 10. There was reasonable doubt in the case.
So for number 9, we have lead investigator Michael Proctor, our favorite, who made sure to call Karen a whack job, babe, and much worse, letting people that he was texting know that she has no ass and that he wished that she would kill herself. He made comments regarding gastrointestinal conditional, as well as using some choice words for Karen Read. But we just basically sat there listening to him read off these horrible text messages that I am fortunate enough to not even know anybody who talks like that. And he's the lead investigator.
And we soft pedaled it here. We didn't even put up the really bad stuff. He said, and he said she her pants. And it's like, come on, grow up.
So number 8 is no body on lawn. And after prosecutors claimed Karen backed into John O'Keefe, leaving him for dead sometime around 12:30 a.m., Canton snowplow driver Brian Loughran testified he drove by the property 3 times with bright lights and never saw a body on the front lawn.
Whoever did this slide is going to be fired. So now number 7, Massachusetts State Police Trooper Joe Paul was put on the stand as a collision specialist. And he said that there was a sideswipe accident that was consistent with the sideswipe accident. But wait a minute, Yoli, you and I both know that the state has a duty to prove beyond reasonable doubt. So that statement is wrong on 2 levels. One, if something is consistent, that doesn't mean it meets the burden of beyond a reasonable doubt. That's number 1. And number 2, I had always thought that the theory was that Karen backed into O'Keefe. This guy, their own expert, is saying that it was a sideswipe accident. So the other points that he made that just make me scratch my head were, he said that an arm strike could cause these bodily injuries. And it's just, I don't know. He had it. Again, I don't want to disparage anyone's education because we all have different paths in life and we should all be respected. But if you're going to put this guy up as your major collision specialist, he only has an associate's degree, no degrees in math, physics, engineering, or anything that's really pertinent to deciding what happened in an accident.
All right. So the hair travels 60 miles attached to SUV. MSP forensic scientist testifies she found an apparent hair on the back of Reed's SUV. She said it was not affixed to the vehicle in any way. It was just on the vehicle. Vehicle had traveled 60 miles from Albert's home to J.O.'s home, back with side chips. Now, as a hairdresser, as a licensed cosmetologist, I can attest hair sticks to places. Although when you're going through the snow, it's kind of like it's almost raining down on your car. It's surprising that they'd even find it in the first place. It's surprising that the hair is there. Just because there's a hair there doesn't mean anything. Is her boyfriend is just like, I'm sure there's 1,000,001 hairs all over my car.
But you're not going to drive. Are you telling me that a hair is going to stick to the back of an SUV for 60 miles?
In the snow, in a blizzard,
No.
I've had, hair stuck to my hand, not hair stuck to my car for 60 miles.
Unless there was gum on the car. I mean,
Gum.
Yeah, gum.
and the hair stuck to the gum.
No.
I mean, this is crazy. Number 5 is the prosecution timeline issues. Massachusetts State Police Trooper Nicholas Garino, a digital forensic specialist, Karen Reed's phone connected to O'Keefe Wi-Fi at around 12:35 a.m. on January 29th. That's what Massachusetts State Police Trooper Nicholas Garino says, which contradicts Jennifer McCabe's testimony that she observed Reed outside Brian Albert's home at around 12:45 a.m. That's inconsistent.
No, both of those things can't be true. And this is the Commonwealth's own case. They contradicted their own evidence. Number 4, the defense experts that were not even paid by the defense included Dr. Daniel Wolf. He is an accident reconstructionist. He had done 1,000 accident reconstructions. 100 or more were pedestrian cases. And he testified there was no damage to Reed's Lexus SUV consistent with a pedestrian strike. He said the taillight damage was inconsistent with hitting John O'Keefe, and the damage to the back of the Lexus is confined to a 6.5-inch length, making the injuries to O'Keefe's arm totally inconsistent. And the thing that's really important about this is that, a lot of times, experts come in and they're paid by this side or paid by that side. And that point is made to the jury. I had my hair expert, Lainey Law, come in today. But Mr. Myers, didn't you pay her? And we paid her $1,000 million to come in today. But here, these people came in as part of the federal investigation, and the defense never even retained them. And in some cases, never even talked to them before they came in. So their credibility was fairly high. Number 3, Lainey.
Number 3, another defense expert that was not paid by the defense, Dr. Marie Russell, MIT, then medical degree, was an emergency room physician, and confirmed that O'Keefe's arms injuries were caused by a large animal and that they weren't caused by a taillight, which, looking at the picture,
How does
fair.
the taillight cause that?
It's like the taillight's broken and you're like scratching.
No.
You shove your arm into the taillight.
No.
Okay.
Number 2, yet another defense expert who was not paid by the defense was Dr. Frank Sheridan. He is a retired chief medical examiner. And he pointed out that O'Keefe's abrasions, the pattern was inconsistent with a vehicle collision. He said the injury was not consistent with falling onto the grass, maybe hard ground, but it was snowing. And he said that O'Keefe's blunt force trauma injuries were consistent with a fight, which is kind of like that's what the third-party culprit defense was all about. So what is the number 1 cup of reasonable doubt?
So number 1 is the property owners were not investigated. The body is found on the front lawn of 34 Fairview Road, Canton. Investigators do not go inside to investigate. And just think about it. If a near-death body were found on your front lawn, don't you think the police would ask questions of the people inside the house?
Yeah, you think? And this was Brian Albert's home, and Michael Proctor had said, "Oh, we're not going to give him any." So
That's
I don't know.
just bizarre.
I would like to know. I would be curious. I would want to know what's going on outside my house. I'm driving down the street and I see police cars and I'm still sticking my head out and Googling what's happening.
Yeah.
Weird.
So those are only 10. I know we're going to get comments. Well, what about this? What about that? What about the butt dials? What about, a lot of other things? There were a lot of things, but, I just sat down and scribbled down 10 things with really, not thinking about it too much. I did go back over my notes and revise it a little bit, but without really even thinking. I don't know. There's just so much reasonable doubt in this case. And I as I tried to be objective, I started out thinking one thing, but I listened to the evidence, and it's so obvious that there was a lot of reasonable doubt in this case that.
And there's bias. I mean, that leads to reasonable doubt because the comments that this guy was making, Proctor, that those comments just reek of bias, and whatever the bias is, it's bad for Karen Read. I mean, he's already calling her a wacko. He's already decided that she did it. She's a wacko.
Yeah, and he wants her to kill herself. And he said those other disgusting things that he said about her. And it's like, in a previous episode, I misread the statement of the Massachusetts State Police. They had, said that he was relieved of his duty, and I said he was fired. No, he's sitting at home collecting his, I think it's $186,000 annual salary, and he's been removed. And apparently there will be a defense for him, and he'll, collect the salary, collect the benefits, collect the pension. And so it's almost like he was rewarded. In my mind, if you get to stay home and still get your full pay, that's almost like being rewarded for his conduct. And that's, the Massachusetts State Police, I don't mind saying it. I know some other creators out there have danced around it and not wanted to address it, but the Massachusetts State Police has a long history of corruption. And even the governor, who's a former attorney general, just kind of, we can't comment because there's an investigation. And I don't know. I don't know what all these politicians are afraid of in Massachusetts. I really don't.
It doesn't make sense because in what other job do you have where you could be doing your work, like going through someone's phone, you're supposed to be doing this, and texting your boss like, oh, I haven't found any nudes. In any other company you work at, you talk about anything remotely close to that, that's an HR issue. I have a client who works at a grocery store that has a very friendly, fostering environment, and it's just like she can't even hug her coworkers without it being, they have very firm what's appropriate, what's not,
guidelines.
In any other industry. The sexual harassment thing is crazy. How is this okay?
It's not
okay. But you know what? Yeah, that's the one thing we forgot to mention in our presentation before is the fact that he said that he was going through her phone looking for nudes. Come on, give me a break. All right. Any final thoughts, guys, before we move on?
It's messy. I'm honestly surprised that they didn't come to an agreement. I think that, like you mentioned, it's just and I don't know at what point, I don't know where someone is completely convinced that she's guilty. I think that even in a scenario is just when you look at it, even in a theoretical situation where she hit him, where we don't even have concrete evidence of that, how are you going to really prove that it was intentional? Because they got into a fight on a date. People fight on the vacation all the time.
It's just
Yeah. Go ahead, Lou. I'm sorry. Go
yeah.
ahead.
It's just this whole case on Karen Reed reeks. It just reeks, and the bias alone, in my opinion, should be enough to cause reasonable doubt. And then there's all those other things, that went along with the phone being destroyed when they was told not to destroy. That was Higgins. And then just all these, it just piles up. There's like all this circumstantial evidence that leads to reasonable doubt.
And one of the jury instructions tells the jurors that if you have reasonable doubt, not any doubt, but if you have a reasonable doubt, you must acquit. So that's fairly certain. That's fairly clear. And so something went wrong here, and we'll just have to watch. And that's what we will need to watch as we go forward. I hate when people end and say, well, we'll wait and see. No, what we need to observe is whether there will be a change in the way the jury is selected, whether there'll be a change in the way the case is presented, whether there'll be a change in assuring that jurors are brought in and questioned to be sure that they are going to give a fair and unbiased analysis of the evidence and not bring in these preconceived notions. Some people call it confirmation bias. I call it preconceived notions. If someone has a certain moral or theological belief that's going to stand in the way of their achieving a verdict one way or the other, that's just wrong. And I don't mind saying it.
Yeah.
Okay. On that pleasant note, anything else, guys?
No.
Thank you guys so much for watching. I'm looking forward to seeing how you guys feel in the comments.
Yep. Please like, subscribe, comment, be kind, be respectful. We do delete comments when people I don't mind people disagreeing with us. People disagree with you no matter what, but we don't want you to personalize it. Other than that, have a great day. Have a great weekend. Be well, folks. You have been watching About the Law, a production of the law offices of Andrew D. Myers in Methuen in the Merrimack Valley of Massachusetts and in Derry, just outside of Manchester, New Hampshire. Remember to click the like and subscribe buttons down below. And if you enjoyed this video, be sure to share it with your friends and others. If you'd like to talk to me about an injury case, a car accident, a slip and fall, a serious bodily injury case, or some other case, please feel free to contact me. I'd love to talk to you. You can contact us through my website at attorney-myers.com. We have a contact us block, or you can call on one of the telephone numbers we've given there, or you can email me at andrew@attorney-myers.com. The foregoing is offered for informational purposes only. It is not intended as and does not constitute legal advice. Laws vary widely from state to state. You should rely only on the advice given to you during a personal consultation by a local attorney thoroughly familiar with state laws and the area of practice in which your concern lies. This podcast must be and hereby is labeled advertisement in some jurisdictions.
And that's that.
And
that's that. All right, guys, have a great week.
Okay.